Greetings. Trying to get off of Facebook here. Just building some memorandums this evening and putting some requests for bar grievance and sanctions against certain individuals tonight. And while I was doing that, I'm always reflecting on the law library with Self-Governance U. And I happened to stumble across Gibson again. One of my favorite mentors, although I've never met him. The more and more you read his extraordinary material, the more and more you feel like you know the man. Pretty incredible how ingenious this gentleman was, and it's caused me to come back on here and do a video for you on Facebook. But again, trying to migrate over to TikTok now. If I get to 1,000 viewers, they say that I will be able to live stream again. Right now on TikTok, I'm limited to 90 seconds, and as much information as I want to give you, I look like a lunatic trying to rush through it as fast as possible. I'm sure I sound like an auctioneer, and I don't think it's conducive for people to learn that way. Maybe it's good, maybe it's not, but nevertheless, 90 seconds isn't enough for the information that I want to give to you guys in one setting. And so because of that, if you can join me on TikTok, that'd be cool, because I would really like to move there where my content isn't being removed, or I'm not being scrutinized or censored by communist Facebook anymore. I just don't have a desire to be here any longer. So with that said, I would rather be on TikTok. You guys be so kind as to join me on TikTok and like, follow, subscribe, whatever the hell you do on TikTok. I'm new to it, but the thing is, we get to 1,000 people, I can start live streaming there. And I've been told by a number of other people that are doing basically the same thing I'm doing, that they absolutely have no problem on TikTok, and they're not being barred for doing things like this. So let's get to it. I was, like I said, putting together memorandums of law this evening, moving for bar grievances, sanctions against certain individuals. And I was digging around the law library for setting some good precedent and refreshing my memory, because a memorandum is kind of just a generalization of the things that you have, whether they be common sense knowledge or things read from a book, but you don't have to quite be so particular. Although I'm very thorough, I think it's important to let them know where you're getting this information from, how you've come to this frame of mind, this way of thinking. In any event, here's Gibson. We're going back into maxims of law, and let's see, how do I want to do this? You guys basically already know the 20 maxims of law if you're in the exclusive jurisdiction of equity that matter. I mean, you can just learn 20 maxims and never have to learn another fucking thing, so long as you're with clean hands and pure intent, and exercise critical thought process. That's really what equity is. It has nothing to do with statutes, nothing to do with codes. In fact, in many instances, the codes and statutes most often are vague, ambiguous. They have no bearing. They make absolutely no sense. They're littered with pronouns, and they don't apply to you. But if you're in that jurisdiction, utilizing that information, it might behoove you to learn some of the stuff that we're going to go over tonight. And I'll quit rambling on. Subsection 41, this is out of Gibson's Maxims and Equity Adjudicate, 1907. And it was a PDF that one of my mentors, when I first started out, gave me. And I just stumbled across it again. It's just a little 16-page ditty out of that 1907 adjudication. But it covers the essentials, okay? Subsection 41, maxims of adjudicated generally considered In the adjudication, if the question that arises in equity, it is seldom that any statute is determinative, and not always that any decision of the Supreme Court is applicable, and hence the Chancellor is forced to rely on the rules of practice and pleadings, and the maxims and the principles of the law and equity as his guides. These rules, maxims, and principles are generally so thoroughly incorporated into the judgment that he uses them unconsciously in making a decision. But if his opinion is written and analyzed, it will often be discovered that these rules, maxims, and principles controlled the decision. The principal maxims on which the Chancellor acts in adjudicating an equitable matter are the following, which might be designated as the 12 tables of equity. 1. Equity acts upon the person, forcing him to do what conscience requires. 2. Equity will not suffer a wrong without a remedy. 3. Equity imputes an intention to fulfill an obligation. 4. Equity acts specifically and not by way of compensation. 5. Equity regards that as done which ought to be done. 6. Equity regards equity requires him who seeks equity to do equity. 7. Equity regards the beneficiary as the real owner. 8. Equity delights to do complete justice and not by halves. 9. Equity acts for those disabled to act for themselves. 10. Equity looks to the intent rather than the form. That one's a really important one. And in the beginning of studying law and legalese and the law of merchant and treaties and constitutions and commercial charters, I really hung my hat off number 10 here. Equity looks to the intent rather than to the form. Because in the legal society, when I first got started, just typically trying to belittle me, basically saying, you don't know enough to do this, Derek. You're gonna end up in prison, just let the court-appointed attorney sell you down the river. And everything about it to me said, too much liability, fuck off, not letting that happen, all right? And one of my mentors said, you made the right choice, and you got to make that on your own. It's a scary decision, especially when you've got alleged debt and a family to feed, and times are troubling. But shall we cast away logic and common sense and decency amongst ourselves while we frolic amongst the shaky economy that they've created just for the purpose of manipulation? I don't think we should throw sound doctrines and principles out of the way. I think we should stand up like men, sound off like we got a fucking pair, and handle our damn business. Because after all, that's how America was founded. It wasn't founded by a bunch of pussies who were quibbling about sand in their vagina. No, quite the contrary. Those men stood for something. They pledged their sacred honor for something that they rightfully didn't even know even existed. It was just a theory, this evolved theory of we can be free without being lorded over by other men who are no better than us. And at the end of the day, more sinister than we are. Not that they were great men back then. The more I learn about the founding fathers, the more I'm kind of baffled by how the history books make them to be such great nostalgic, men of honor. They were once young too. They made frivolous, arrogant mistakes. The times were different. The values were different. And therefore, the perception of right from wrong was a little different back then too. In the context of thinking that you can own another living soul, another man, for example, is what I'm leading at. But anyway, I was ostracized a lot by the legal society saying, hey, you don't know what you're doing. The forms, you're not doing the forms right. I'd have the clerk of the court tell me, I can't allow you to submit that. And, I was just in the beginning stages, and I said, fine, I guess then we can't do business. If you're not going to allow me to file this document because it doesn't meet your structure and your fucking form, fuck you, I'm out. Good luck explaining that to the judge. And as I was walking out the court, she's like, wait, I'll take it. That's what I fucking thought. And, it wasn't the most eloquent. My spelling was absolutely fucking horrendous. If anybody could have made 2 cents of it, I would have been impressed. Looking back on it, I was like, damn, I struggled reading this. But I made my point. It's pretty fucking clear. Leave me the fuck alone. Leave me the fuck alone. All right? And the judge was like, well, this would have to be submitted a different way. And I said, equity looks at the intent and disregards the form. See, you and I as common laymen are not expected to practice, quote unquote, the law like these people do. And even by their own nature and design, where they say that they practice, even they don't have it fucking perfected, guys. I mean, it's that simple. They've been practicing law for what? 800 years, according to the London Guild. It's been going on since the beginning of the ages. I mean, according to the Bible, woe unto you lawyers, right? So for all this time, nobody's managed to perfect the law. But I know of one who has, and that's the Heavenly Father. And then through terrible times, greater men than myself, poised, sat back and looked at the behavior and the rigid structure of what man had constructed as law, and realized that so often the way that the law was structured by man was wholly inadequate for providing remedy to anybody. If but one or two, then who for, right? If only one or two got what they sought through the law perceived and constructed by man at that time, then it wasn't worth it. And that's where the beauty of equity comes in. Because they were sitting back going, wow, this system just isn't right. It doesn't provide like it should. And so they sat back, and that's how equity really developed. Blackstone, he's on the back side of it. He was elder in his years when he started to discover equity. So you'll find a lot of legal scholars that say, Blackstone didn't really have it figured out. But then you get to Joseph Story, Pomeroy, Henry R. Gibson, John Marshall, and you look at some of their works, and they were really starting to figure it out. But I think Joseph Story nailed it the best. Henry R. Gibson right there as well. Number 11, equity delights in equality. Number 12, equity requires diligence, clean hands, and good faith, which means you cannot slumber on your damn rights. You have to get off your ass and get to it. And if you need a drill sergeant to yell and scream, rant and rave, I'm your fucking guy. I will chew your ass at every fucking turn. The people that hang around me almost dread when they bring something to me, because I look at it and I go, are you fucking kidding me? Are you not reading? Are you not evaluating what you're doing? Are you just frivolously copying shit off the internet and posting it into fucking your documents because it looks like shit, and anybody can see that? So focus, because this is your life we're talking about, right? You're leaving a paper legacy behind with your good works. And I'll be the first one to tell you, I used to copy people's shit all the fucking time. Eventually you will have to evolve to the point where you can write your own shit out of your own head. And then when you're tested in those courts and they know that you know who you are and what the fuck is really going on, they are far less likely to play with you. All right? If you plagiarize shit, they ask you some questions, you don't know how to answer them, they know. It's a lot like you lying to your dad when you was a kid. He knew you was fucking lying, and you'd be damn lucky if you didn't catch the belt. Or worse, So think about those things. These people that are set up on that bench, they're not there because they're fucking stupid. All right? They read a lot. Most people that are in those positions of sitting on those benches, they don't have no fucking friends because nobody wants to hang out with them. And the other thing about it is they read so much, it's hard for them to have an articulate conversation with anybody. Okay, and granted, they do hang out with the thieves. They hang out with the lawyers all the time. Old Martha, her poor ass up in the kitchen, making blueberry muffins laced with pot for the boys downstairs, drinking gin and smoking cigars and playing fucking cards, debating on, the sentence that you're going to face or how they're going to take your kids. All that shit's all decided before they ever get into a courtroom. In most instances, if you don't do your paperwork. Some of these maxims have been considered in the preceding articles being also maxims of jurisdiction. Now again, this comes from Henry R. Gibson's Maxims Equity Adjudicated 1907 volume. Subsection 42, he who comes into equity must come with clean hands. This maxim declares that a complainant who has been guilty of unconscious conduct of bad faith, or has committed any wrong in reference to a particular transaction, cannot have the aid of a court of equity in enforcing any alleged rights growing out of such transaction. The Court of Chancery was regarded by the ecclesiastical chancellors as a temple into which none could come exempt except those who had clean hands and pure hearts. In the origin of the jurisprudence, the theory was adopted that a court of equity interposed only to enforce the requirements of good conscience and good reason as to matters not equitably determinable in the law courts. And this interpretation being deemed a matter of grace, it would not be exercised in favor of a person whose conduct in the matter he had complained of had been unconscious or in bad faith, or who had violated any of those principles of equity and righteous dealings which the court had been construed to enforce. But the operating of the maxims is confined to misconduct connected with the particular matter in litigation, and does not extend to any misconduct, however gross, which is unconnected therewith, and with which the defendant is not concerned. Sorry, this is all scanned in, so although it's in a PDF form, some of it's blurry. Under the operation of the maxims, the complaint must show that the transaction from which his claim arises is fair and just, that there is nothing unconscious in his conduct relative thereto, and that the relief he seeks is equitable and not harsh or oppressive upon the defendant. Hence, a specific performance will be refused when the complaint has obtained the agreement by sharp and unscrupulous practices, by overreaching, by concealment or important facts, by taking undue advantage of his position, or by any unconscionable means, or when the contract itself is unfair, one-sided, unconscionable, or affected by any other such inequitable circumstance, or when the specific enforcement of the agreement would be oppressive upon the defendant, or would in any other manner work injustice. So, if a contract is affected with fraud, or has a fraudulent purpose, none of the parties to such can have the assistance of the courts, either to compel the execution of such contract, or to have it canceled, or to have the property or interests transferred thereunder restored. Equity will leave such parties where they have placed themselves, and will refuse all affirmative aid to either the fraudulent participants. It is upon the principles that the door of the courts of equity is always shut against a debtor when he seeks to recover back property he has conveyed to hinder, delay, or defraud his creditor. No right of action arises out of fraud. Agreements and transfers, the consideration of which is based on a violation of chastity, or on a compounding a felony, or on gambling, or on the commission of any crime, or on any breach of good morals, are all deemed illegal, and no participants therein can get any relief in the chancery court, whether the relief sought is an enforcement of the agreement or a rescission of it. Where parties are equally in the wrong, the condition of the defendant is the stronger, but where the parties are not in pari delicio, and where public policy is promoted thereby, the more excusable of the two may be granted relief by the court, setting aside the agreement and restoring him to his original position. A court of chancery will not enforce an usurious contract, even when the defense of usury is not made. Property law, but will relieve against usurious contracts, and will also restore money or property lost upon any gain or wager. Subsection 43, equity looks to the intent rather than the form. This maxim is, there are several maxims akin to this. He who cometh into equity shall not have equity. No right of action arises out of an immoral transaction. Where both parties are equal in fault, the situation of the defendant is stronger. All right. This maxim is connected with the one that says equity regards that as done which good conscience ought to have been done. For it is only by looking at the intent rather than the form of the transaction that equity can treat as done what ought to have been done. The two maxims act together and aid each other, and with the further help of the maxim that equity imputes an intention to fulfill an obligation, a court of chancery will not only hold a resulting trustee or a constructive trustee liable as such, but will impute to him an intention to act as such regardless of the form of the transfer or conveyance. Equity heeds not forms, but strives to reach the substance of things, and to ascertain, uphold, and enforce rights and duties which spring from the real relations and the actual transactions of the parties. Looking to the intent rather than the form, whenever a penalty is designed merely to secure the payment of a given sum of money or performance of some act, equity will relieve the obligor from the penalty upon his paying the debt or the actual damages resulting from his default. So if a lease has been forfeited for a non-payment of rent or for breach of some but not all of the covenants contained in the lease, if the lessor can be adequately compensated for the breach of the contract, equity will regard the forfeiture clause as merely a means of securing the observance of the contract, and a court of chancery will relieve from the forfeiture. So looking at the intent rather than at the form of the contract, equity will consider the forfeiture clause in mortgages and trust deeds as merely means of enforcing the payment of the money contracted to be paid, and will relieve from forfeitures incurred upon the payment of the debt. Equity will also, upon parole evidence, convert an absolute deed into a mortgage, and will in general, unless prohibited by some statute, set up and enforceable the real contract of the parties regardless of the form or of the want of form. For equity looks not at the outward form, but to the inward substance of every transaction, recurring to principle and disregarding ceremonies, looking upon forms as made for justice, and not justice made for forms. Where there is substance for the court to act on, the want of a form will be disregarded. For equity regards substance and not ceremonies. This is true not only in adjudicating the equities of the parties, but is true in matters of the pleadings also. Thus, if the bill makes out a case for relief, any want of formality or any misnomer of the bill or any intrinsic, I can't say it, eccentricity of phraseology will not defeat the complaint's right to relief on the facts alleged and proved. So, if the necessary parties are before the court and a case for relief is alleged and proved, the fact that parties are made complainants who should have been made defendants, or vice versa, will not prevent the court from decreeing according to the equities of the parties. And this is so even when persons under disability are to be affected by the decree. The fact that the proper facts are alleged and the proper parties are before the court is substance. The manner of alleging the facts and the position of the parties in the suit is ceremony. No one is presumed to give something for nothing, and no one can, in reason and conscience, expect to receive something for nothing. Whenever a person parts with a consideration, he is presumed to intend to acquire whatever that consideration pays for, and he who acquires the legal title to property for which another's money has paid is bound in reason and conscience to hold it subject to the orders of the person whose money went into it. Reduced to the last analyst, the property acquired by another's money is only that money in another form. And property conveyed without receiving another's money, therefore, continues. In equity, the property of the conveyor, hence, it is the passing of the consideration and not the form of the contract that in equity passes title. And whatever the form of the transaction, if no consideration passes in equity, no title passes. All right. When we come back, I'll end up going through all these because they're just too damn good not to. You guys all need this in your arsenal. And I'm sorry for stuttering through it. It's late. And again, these aren't the clearest photocopies. This is what James did when he was younger. He'd go into the law libraries and he'd sit there and he would scan in books all day, page by page by page. And we are just fortunate enough to have those great works. So anyway, with that said, appreciate you joining me. I'll come back on later. When we come back, we'll be talking about equity imputes an intention to fulfill an obligation. I believe that is the next one that we're on. Yep. And that's what I'm always talking about when people say, well, they didn't take their right oath. They're not properly bonded. Equity imputes an intention to fulfill an obligation. I don't give a shit if they got the right oath or not. Doesn't make a flying bit of fucking difference, all right? Because the second they received their first paycheck, they were bound by that oath that they were supposed to take in the first place. Anyway, I'll see you guys here after a little bit. Maybe I got a little bit more work to do, and I'm going to pre-read this again because it's been a while, and I'm struggling with it. And that way, I'm not so choppy through it as well. So, anyway, with that said, love you guys.